Hello everyone, welcome to the video lecture on Intermediate Paper number 5, Business Law and Ethics, CMA Inter. Previously, we were covering various chapters of this study material. Today, we are covering module number 4, Negotiable Instrument Act 1881. So, as you are aware, we are having discussion on examination point of view. This will not be a detailed video lecture, whereas we will be covering important concepts and explaining them. Considering the previous examination, this chapter, the method of a question has been in two ways. One, directly asking about certain concepts. It can be difference between A and B, or a direct question like what is so and so. Another way of asking question is a scenario will be given. Considering the scenario, you will be asked to give a legal opinion. These two way questions are asked in previous question paper. So, as you are aware, Negotiable Instrument Act 1881 is the governing act. So, what is a negotiable instrument? Are we aware of any negotiable instrument? The classic example for a negotiable instrument is cash. Take a 500 or 2000 rupee note, or any note for that matter. You will be able to see in the note on the back side, I promise to pay the bearer sum of so and so, and the signature of RBI governor. So, cash is a negotiable instrument. What makes it different from an ordinary piece of paper is that promise or undertaking. That signature of RBI governor and the promise makes it a negotiable instrument. Negotiability is a feature that is distinct from the concept of transferability. By bare delivery or endorsement and delivery, the acquirer of a negotiable instrument is the best title to the instrument by becoming the holder, which is not the case in instruments that are not negotiable, and can bestow upon such rights by the procedure of sale and other means of transfer. So, when Mr. A hand over a 500 rupee to Mr. B, Mr. B is the holder of 500 rupee. That is, the possession and the ownership of the title on the negotiable instrument is transferred from person to person. So, what are the features of a negotiable instrument? It must be in writing. It should be signed by the maker or drawer. There must be a promise or order to pay. The promise or order to pay must be unconditional. It must call for payment in money and money only. It should call for payment of certain sum. The property in the instrument may be passed in two ways, by mere delivery or by endorsement of delivery. The consideration is presumed to have been passed. All this feature, if you are paying attention, you will be able to see in cash. It is written, it is signed, the amount is mentioned, and all the features you will be able to see. You can take one cash, any rupee note, and see all these features available. So, what is a promissory note? A promissory note, as an instrument in writing, not being a banknote or currency note, contains an unconditional undertaking by the maker to pay a certain sum of money only to or to order of a certain person or to bearer of instrument. In a promissory note, there are two different parties. One is the payer, other is the payee. Such instrument can be negotiated when endorsed and delivered or be delivered only. So, what is it? What is it the difference? What is the difference between promissory note and a cash? Here, there is an unconditional undertaking by the maker to pay a certain sum of money. That means the transfer or the payment has not happened in the present. The promissory note means the maker pays promise to make the payment in future. Whereas in the case of cash, one transfer, it becomes effective. The moment it is transferred from A to B, it is becoming effective. In the case of a promissory note, payment is effective only when in future only. Some examples you can see here. I promise to pay B an order of 50,000. This and all you will be able to see in movies also. So what is a bill of exchange? Bill of exchange is an instrument in writing containing an unconditional order signed by the maker, directing a certain person to pay a certain sum of money only to or to the order of a certain person or bearer of instrument. Example, a promise or an order to pay is not conditional within the meaning of this section by reason of time for payment of amount or any installment thereof being expressed to be on the lapse of a certain period after the occurrence of a specified event, which according to the ordinary expectation of mankind is certain to happen, although the time of it happening may be uncertain. So, what is a bill of exchange? The most important keyword is containing an unconditional order. Unless you are able to write unconditional order, you will not be able to score with respect to bill of exchange. It is the most important keyword. You have to have this word in the answer, otherwise, you will not be able to score. What is it, bill of exchange? An instrument in writing containing an unconditional order signed by the maker, directing a certain person to pay a certain sum of money only to certain person. So, bill of exchange says, I am promising I will pay so and so, or I am promising Mr. X will pay so and so. So, bill of exchange is as simple as that. Signed by the maker, directing a certain person to pay a sum only to or order of a certain person. You all will be aware of what is a check. It is a bill of exchange drawn on a specific banker, not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check and check in electronic form. So it is a kind of bill of exchange. Check is a kind of bill of exchange. So who are the parties to a check? This you should be very well aware. Drawer, that means the maker, drawee, to whom it is drawn, and payee, who endorse or make the check pay submitted to bank. That is called payee. Drawer, drawee, and payee. Three parties are there in case of a check. What is a truncated check? A truncated check is which is truncated during the course of clearing cycle, either by clearing house or the bank, whether paying or receiving payment immediately on generation of electronic image for transmission, substituting the further physical movement of check in writing. So suppose Mr. A write a check for 1 crore to Mr. B. Then Mr. B submitted to bank that check. Can the check be again used? No. That is the truncation of check. It means a check can be used for only one time. That is, further use is restricted. So truncated check is a check which is truncated during the course of clearing cycle, either by the clearing house or by the bank, where payment or received payment immediately on generation of electronic image for transmission, substituting the further physical movement of check in writing. These are all possible method of asking question in exam. There will be a differentiation. Most repeatedly asked is difference between promissory note and bill of exchange. I always suggest my students, unless you're 100% sure, it is better suggested not to quote section. So in case of a promissory note, there are maker and payee. Whereas bill of exchange, there are three parties: drawer, acceptor, payee. It contains a promise to pay. It contains an order to pay. This is the key difference. In a promissory note, there is a promise. In a bill of exchange, there is an order. No condition shall be made in a promissory note. In a promissory note, there will be no condition. A bill of exchange may be accepted conditionally. The liability of a maker of promissory note is primary and absolute. The liability of drawee of a bill of exchange is secondary and conditional. So, what does it the meaning of liability of a maker of a promissory note is primary and absolute? It means always in case of a promissory note, the owner will be the person who will be making who is the primary party. That is, the liability of maker of the promissory note is primary and absolute. There is no authority to challenge the maker of a promissory note. He is the absolute authority. Whereas in case of bill of exchange, the liability of drawee of a bill of exchange is secondary and conditional. It is transferred from person to person. Promissory note versus check. In promissory note, as we said, there is a maker, payee. There are three parties: drawer, drawee, and payee in case of a check. Promissory note contains a promise to pay the sum with interest or without interest at a later date. A check is payable immediately on demand without any days of grace. Promissory note is crossed. Check can be crossed. Check need not be crossed. It can be. No protection is available to payee of note. Statutory protection is given to drawee banker. A promissory note cannot be self-drawn. A check can be self-drawn. No criminal liability can be imposed on maker. Criminal liability can be imposed on drawee for dishonor of check in certain circumstances. So every financial matters usually come under civil nature, civil liability, except dishonor of check. Dishonor of check is a criminal liability liable for imprisonment up to 2 years. Stamp is necessary in case of promissory note. Check stamp is not necessary. What is there is what is limitation period? Suppose any event happened, there is a time prescribed under our law within which you have to approach court to get any legal remedy. That is called Limitation Act. So in case of promissory note, limitation period is 3 years. In case of check, it is only 6 months. What is difference between bill of exchange and check? It is defined in section 5 of a Negotiable Instrument Act. Check is section 6. There are three parties in bill of exchange: drawer, drawee, and payee. There are three parties in check: drawer, drawee, payee. Bill of exchange are not crossed. Check can be crossed. If you have a fair idea of concept, you will be easily able to bifurcate or discriminate the points. Generally, 3 days of grace are given for payment in case of bill of exchange, whereas in case of check, there is no days of grace. Anybody, including banker, may be drawn in case of bill of exchange. In case of check, draw is always banker, not baker. it must be accepted before the acceptor can be made liable upon it. It requires immediate payment. It does not require acceptance of maker. Thus, the question of acceptance does not rise in case of a check. Check is immediate payment. Bill of exchange is not paid, not honored. A notice of dishonor should be sent to the drawer to charge him. When a check is dishonored, notice of dishonor is not strictly necessary. The banker can return the check with the memo referred to drawer with a sufficient notice. See, in case of bill of exchange, if that is dishonored means you have to give notice to the maker. Whereas in case of check, there is no such requirement. Always the maker should be very well careful before making a check. There is no requirement for any notice. Statutory protection is not available in case of bill of exchange. It is well protected. Check is well protected. Civil liability in case of dishonor of bill of exchange. Criminal liability in case of bouncing of check. So we discussed it for all parties too. So what are different kind of parties? Their power you can go through. What is the difference between holder and holder in due course? Holder is entitled in his own name to possess the instrument and the amount thereon from parties involved. Holder in due course possesses the instrument for consideration before maturity in good faith. The title of holder is subject to title of transferor. The holder in due course gets better title than transferor. The holder may receive instrument without consideration. Holder in due course always receive the instrument for consideration. Holder do not get certain privileges available to holder in due course. Holder in due course always get privilege not available to holder. So what is the difference? Holder is entitled in his own name to possess the instrument and the amount thereon from the parties involved. Holder in due course possesses the instrument for consideration before maturity in good faith. So certain times, certain negotiable instruments will be transferred from A to B to C. Maybe it may be getting expired in future, but in the process it get transferred. Any holder of negotiable instrument before the maturity happen is called a holder in due course. Holder is entitled in his own name to possess the instrument and the amount thereof from the parties involved. So, to strictly speak, holder in due course at the time who is holding is in holder in due course and maturity has not happened. He has in better title compared to holder. The various types of instruments you can go through. So, maturity you might be knowing the maturity of a promissory note or a bill of exchange is the date which falls due date. This is a repeatedly asked question. Student must be well aware of the topic. This is called crossing of check. You know what is a check? A check can be crossed or not crossed. Crossing itself, there are different kind of crossing. You might be able to see two lines in check in corner before it is presented to payment. By drawing such line, there are certain additional restrictions which bank has to follow. So what are they? What are the different modes of crossing? General crossing, special crossing, check cross specially more than once, due course cross to check of due course. We can go through the important. Check is crossed generally. The banker on whom it is drawn shall not pay it otherwise than to a banker. Section 127 provides that where a check is crossed specially to more than one banker, except when crossed to an agent or for purpose of collector, the banker on whom it is drawn shall refuse payment thereof. Section 128 provides that where the banker on the whom cross check is drawn has paid the same in due course, the banker paying check and the drawer thereof shall respectively be entitled to same rights as and be placed in same position in all respects, as they would respectively be entitled to and placed in it if the amount of check has been paid to and received by true self. So I'll explain what is it. When in corner of check there is only two line, it is called general crossing. There will be nothing written there. So what happens when it is crossed? There is something called blank check or not cross check. What happens a check when it is not crossed? A holder can present it to the counter and get that check credited to any account, even if it is possible to get it cash if it is within the limit. Of course, a check can be taken by cash or even be credited to any account of any bank. Suppose if it is crossed means for in whom's name the check is drawn, to that person's account it has to be directly credited. Okay, it has to be directly credited to the person whom the check is drawn. That is called general crossing. What is the difference between special crossing? So suppose there is two line and in between it is written account pay or some special condition. In such cases, there is a certain liability rising on banker. Any defect or for failure to comply with the crossing will give legal liability on the bank. That is the key difference. In case of special crossing, bank becomes legally liable in case of any failure to carry out or discharge its performance. Strictly speaking, it is a more strictly form of crossing, specially closed. General cross is comparatively less serious. It does not make bank that much legally liable. There are other kind of crossing. Account pay check is there. There where two lines are drawn in between, it will be written account pay, and other kind of two line drawn and in between bank name is written. So only check can be credited to that bank account of that bank. If it is written SBI, only SBI it will be credited. So like that, certain condition, different types of crossing are there. Students should go through the different types of crossing, and minimum three to four you should be well aware. Endorsement. What is endorsement? So to make it very simple, A go to bank, A draw a check in favor of B. Mr. C is carrying the check in favor of B. So he went to bank, is crediting the check in favor of B. That time bank will ask what? He will ask the Mr. C to sign on backside of the check. That is called endorsement. Endorsement means signature of the person who are generally made at back of the instrument for the purpose of transfer of right to another person. We all discussed it. There are three parties, no? Maker or drawer, drawee, and payee. Here, payee is the person who endorses. It need not be necessarily a same person. Section 15 provides that when the maker of or holder of the negotiable instrument signs the same, otherwise than as such maker for the purpose of negation on back or face of it, or on slip of paper annexed to it, or no, so signs for the same purpose a stamped paper intended to be completed as negotiable instrument, he is said to endorse the same and is called endorser. The person who endorsement is doing is called endorser. Spelling, please don't get confused, okay? Endorsement is E, endorser is I. So what are the essential elements for a valid endorsement? It must be on the instrument itself or on a separate slip of paper called allowance attached thereto. For the purpose of negotiation, it is signed by the endorser. The instrument may contain in addition to the signature of endorser, then say the name of the endorsee also. No particular form is in form of words is necessary for endorsement. Endorsement is complete when instrument is delivered to endorsee with intention of passing the property into the endorsee. Delivery is to be made by the endorser himself or someone in behalf. So you can go through the essential elements of an endorsement, valid endorsement. I would suggest my students to please be very well aware of different types of endorsement. There are blank, full, restrictive, and conditional endorsement. These are four types of endorsement. It is a repeatedly asked question. So what is it? If an endorser signs his name only, the endorsement is blank. If he adds a direction to the pay the amount mentioned in instrument to or to order of a specific person, the endorsement is said to be full. The person is specifically is called the endorsee of the instrument. Section 49 of the Act provides mechanism of conversion of a bank endorsement into a full endorsement. As per Section 49, the holder of a negotiable instrument endorse a blank may without signing his own name by writing above endorser's signature a direction to pay to any person or endorsee convert the endorsement in full and the holder does not thereby incur responsibility of the endorser. Hmm. So there are different forms of endorsement. When nothing is mentioned, name only is there means blank. If somebody has to do, but in particular, it is full, and there can be some conditions mentioned, or there can be some restrictions also. You can just go through that. So here we discussed when is it blank. When his name only is mentioned, it is called blank. When certain person has to specifically do, it is called full endorsement. When follow as per endorsement of a negotiable instrument followed by delivery thereto has the effect of transferring the property in the instrument to endorsee with a full right to negotiate the instrument, but the endorser may with express word restrict or exclude such rights in which it will create a restrictive endorsement. Usually in negotiable instruments the rights are completely transferred. Where there is a restriction on transfer of right, it is called restrictive endorsement. Section 50 of Negotiable Instrument Act, followed by delivery transfers to endorsee the property therein with the right to further negotiation by, but the endorsement may be express words, restrict or exclude such right, or may merely constitute the endorsee an agent, endorse the instrument, or to receive its contents from endorser or such other specified person. Okay. These examples and all you can go through. This is important acceptance. A bill is said to be accepted when the drawee, after putting his signature on it, either deliver it or give notice of such acceptance to the holder of the bill or some other person on his behalf. So, drawer who makes is the maker. Drawee is who it is the instrument is subjected or directed to. When drawee accept it, it becomes acceptance. So, presentation for acceptance may be excluded in following cases where death, fictitious person, it cannot be found, refused. This is a seen in question. What are the different modes of acceptance? There are general acceptance, there are qualified acceptance. General acceptance, an acceptance is said to be general when the drawee accepts the bill without qualification to the order of the drawer. If acceptance is not absolute, the holder may treat the bill as dishonor by non-acceptance. So when there is no qualification or condition, here qualification means not the qualification we use in plain language. This is legal language. Qualification has different meaning Qualification has different meaning. So, what is qualified acceptance? An acceptance is said to be qualified when the drawee accepts the bill subject to qualification. It may be noted that an acceptance will not be treated as qualified acceptance unless qualification is expressed on the bill in the clearest language. The qualification may relate to an event, amount, or a place. Qualification here means a condition. Okay. General acceptance means there where there is no qualification. Qualified acceptance means where there is qualification. What are the circumstances where there can be a qualified acceptance? Where it undertakes the payment on happening of an event, there it stated. Where it undertakes payment of part only and the sum order to be paid. Where it undertakes the payment at a specified place of his choice and not otherwise or other elsewhere. Where it undertakes the payment at a time. These are all generally conditioned. If wherever there is specific condition, it is called qualified acceptance. So what are the effect of qualified acceptance? The holder may treat the bill as dishonored due to the non-acceptance and after giving the due notice of dishonor, sue the drawer and prior endorsers. If he accept a qualified acceptance, all prior parties whose consent is absolute or discharged as against the holder and those deriving title from him. So, so what are the effects? You can go through here. So, examples accepted payable when in funds. A bill drawn for 1000 rupees accepted 900. So, these are all qualification conditions put. So, what is negotiation? When a promissory note, bill of exchange, or a check is transferred to any person so as to constitute that person the holder of thereof, the instrument is said to be negotiated. Simply meaning negotiable instruments, transfer of negotiable instrument is negotiation. It is not the negotiation in plain language, this is legal language. Negotiation. What is negotiation by delivery? Provide that subject to the provision of Section 58 of a promissory note, bill of exchange, or a check payable to bearer is negotiable by delivery of thereof. There is an exception to this. A promissory note, bill of exchange, or a check is delivered on condition that it does not affect place except in certain event is not negotiable unless that event happens. Normally, negotiable instrument is negotiated, that otherwise transferred when delivery take place. When it is transferred from X to Y, it is negotiated or transferred. This is a repeatedly asked question. The difference between negotiation and assignment. What is an assignment? Assignment takes place when the holder of an instrument transfer it to another so as to confer a right on the transferee to receive the payment of instrument. All negotiable instruments are chosen in action as such as transferable by assignment without endorsement under Section 130 to 132 of Transfer of Property Act. Assignment of a negotiable instrument is effected by writing without endorsement. The main feature of assignment is that assignee obtains the right of the assigner. Therefore, if assigner's title is defective, assignee's title will also be defective. So, what is assignment? When holder of an instrument transfer it to another person so as to confer a right on the transferee to receive the payment of instrument. I have certain rights. I am giving it to X. That is called assignment. What is negotiation? Consideration is presumed until contrary is presumed. Consideration must be proved. This is the correct. Negotiation is affected by delivery in case of instrument payable to bearer, by delivery and endorsement in case of transfer payable to order. Assignment is effective only by writing. This is a key difference. Assignment should be in writing, whereas negotiation can happen or is affected through delivery. So discharge from liability by cancellation, release, or payment. So liability of endorser and all you can just read. So dishonor, means non-acceptance. This please be aware, okay? What is noting, what is protested. So you know what is dishonor. So when a check is presented, bank refuse the payment to be cashed because of because of the fault of the maker. It is called a dishonor. So what happens when it is dishonored? The holder may cause the dishonor to be noted by a notary public. Upon the paper attached to it and partly upon each, the noting must be made within reasonable time after dishonor. There is 6 month limitation act for check. The noting must be specifically specify the date of dishonor, the reason for assigned for such dishonor, and if instrument has not been expressly dishonored, the reason for the holder treats it as dishonor. So basically, notary note the dishonor. That is called noting. The certificate of noting is called protest. Provide that when instrument is dishonored, the holder may cause such dishonor to be noted and certified by a notary public. Such certificate is called protest. Contents and all you can go through. So these are the important topics. So thank you for watching.